So this Young Thug trial has been absolutely crazy from the beginning. Thug was indicted all the way back on May the 9th, 2022, meaning that we're coming up on 2 years since the indictment took place, and the trial started in November of 2023, so almost 6 months since the trial started. Bro has legit spent 60, 70, 80 days in the courtroom going through this trial as of right now, and there has been a lot developed. Now, ever since I covered the Melly trial, I've been getting requests from people to start doing more courtroom stuff, and I hear y'all, I be wanting to. But the only big trial going on in hip hop right now is really the Young Thug one, and I'm kind of late to the party. Bro is already 70 days in. So instead of covering it from the beginning to the end like I did with the Melly trial, I thought we could go ahead and go over all of the key moments from this trial so far. So this video will be great for anybody who ain't been following it day to day and just kind of want to get the rundown of everything that's kind of going on in this trial. So with that said, let's go ahead and get into some of the details. Now, I'm not going to do a full breakdown of every crime that was committed and stuff like that, but I'm going to go over just some of the basics for those of you who may have just now started to follow along. So we got Young Thug, Jeffrey Williams. Bro was indicted, man, running up on 2 years ago now in Atlanta on 8 different criminal charges, including conspiracy to violate the state's RICO statute. Now, Young Thug was initially charged along with 28 people in this sweeping indictment. Although as time went on, that number went down, eventually to 20, then to 14. But it was a massive indictment nonetheless. Now, the indictment basically claimed that Young Thug had formed and started a gang called YSL, or Young Slime Life. Now, the state alleged that Young Thug started this gang back in the early 2010s, specifically they said 2012, and they said that YSL wreaked havoc on the city. In this case, we had people charged with attempted armed robbery, all the way to very serious murder charges. Now, I could go on and on about everything that was in the indictment, but I think most people on this video are probably familiar with this. So with that laid out and everybody aware of why Young Thug was indicted, let's get into some of this footage and some of the details. Now, with all these charges and all these people rounded up in this investigation and this indictment, from pretty much the start of this case, like before we ever even got jury selection for Thug's portion of this case, we started seeing people start to cop plea deals and give details about crimes that had happened.
Defendant and his fellow YSL associates committed the drive-by shooting referenced in sections 3 and 4 above on behalf of YSL and to increase the notoriety, reputation, and fear of YSL. Number 6, defendant admitted committing and was convicted of aggravated assault and participation in criminal street gang activity, among other charges, for his participation in the drive-by shooting referenced in sections 3, 4, and 5 above. Number 7, defendant was told by another YSL associate that immediately after the murder of Donovan Thomas Jr., YSL associates met at the McDonald's on Cleveland Avenue in Atlanta, Georgia, to discuss the murder. Number 8, defendant personally knows that one or more YSL associates committed the murder of Donovan Thomas Jr. on behalf of YSL. Number 9, on January the 10th, 2015, after the murder of Donovan Thomas Jr., defendant and other YSL associates gathered at the home of Jeffrey Williams, aka Young Thug, who gave defendant and other YSL associates cash money to lay low.
So as you can see, the prosecution was reading off this list of things that had happened, and she got these details from a dude named YSL Slug, also known as Tick, real name Trontavious Stevens. Now, he was wrapped up in this original indictment as one of the original co-defendants, but he took a plea deal basically from the start and agreed to testify truthfully in the Thug trial. As part of his plea agreement, he also agreed to not invoke his Fifth Amendment rights when he got on the stand, meaning that he couldn't plead the Fifth and remain silent when the prosecution started asking him questions on the stand. He agreed to be truthful about everything.
On February 4th, 2021, you participated in a group chat with fellow YSL founder Jeffrey Williams, aka Young Thug, and YSL associates Wooney Lee, aka Slime Life Shorty, wherein Jeffrey Williams stated, "YSL rule the world, kid. Y'all just start bringing me the money. Man, y'all stop playing with me." Do you acknowledge that?
Yeah.
Do you acknowledge that on May 13, 2021, you participated in another group chat with fellow YSL founder Jeffrey Williams, aka Young Thug, and YSL associates Martinez Arnold, Miles Farley, Quantavious Greer, Antonio Sumlin, Wooney Lee, wherein Jeffrey Williams asked, y'all ain't beat him up or shot him yet? Then states, y'all getting soft.
Yes.
Now, he was eventually convicted and received a 10-year sentence with 2 years time served and the rest on probation. But when bro started flipping right out that gate, like before Thug even had jury selection done, you could tell that this case was going to be a little wild. That's because not only was this guy Tick taking the stand, but he was also allegedly the co-founder of YSL. And after he agreed to testify, we started to see numerous plea deals get caught by members of YSL. Everybody except for Thug himself got a plea deal, which made it pretty obvious that the prosecution had one goal in mind here. They wanted to take Thug down. They seen him as the head of the operation. He's the one that they're going after. So with that, they were offering plea deals to anybody that could give information. But it also kind of shows that maybe the prosecution went into this with not very much evidence, because when you need to offer this many plea deals, it basically says that you're now trying to become reliant on those witness testimonies, right? It becomes the backbone of your case, which kind of indicates that maybe the prosecution didn't have as strong of a case against some of these people as they thought they did first going into it. Which in the legal system, if you arrest a bunch of people, 28 of them, and you got a strong case against a couple but a weak case against these other ones, if those other ones fall apart, it could ruin the entire case. So it could be that they were offering these plea deals because of that. It could also be that they just wanted to scare them and that this was a tactic to get the testimony out of a bunch of people. Either way, it worked, because right after we found out that Tick was going to be testifying, we got news that another man named Antonio Sumlin, also known as YSL Obama, also copped a plea deal.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you are not a United States citizen, a guilty conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would, and that this is true regardless of any advice by your attorney or anyone else?
You can get deported.
Are you a U.S. citizen?
Oh, yes, ma'am.
Now, bro's plea deal was basically the same as the last dude's plea deal. He said that he would testify truthfully if called upon. Now, I don't think he's testified in this trial so far, but he took a deal saying that if he was called, he would testify truthfully. And he was given the same 15 years of probation as the last guy. And a lot of people are like, yo, they getting sweet plea deals. Bruh, my only argument against that is if you think as a gang member, 15 years of probation is a sweet deal, you tripping, because if you part of a gang, you probably not gonna make it 15 years without a violation of some kind. So I personally think they was handing these dudes these 15 years of probation because they know they're going to get them in the future. But he copped a plea deal too. And keep in mind, all of this is pre-trial that we going over right now. This is the stuff that happened before trial even started. The next person to cop a plea deal in this case was Quantavious Greer, also known as Unfunk, which is Young Thug's brother. Now, I did a video about Unfunk. It's since been removed from YouTube, but I did a whole video about Unfunk, and his story is basically back a decade ago. He got arrested for a murder in Atlanta. He spent a lot of time in prison on that murder charge, with Young Thug funding his attorney, to the point that he eventually would get released from prison and be able to enjoy his freedom. Well, he was wrapped up in this YSL indictment too, basically less than a year after he was released from prison. And pretty much as soon as he got hit with these charges, he got the plea too. The only difference between his plea and the other people's plea was he retained his right to plead the fifth if he was caught on the stand, meaning that if they asked him a question on the stand and he felt like could self-incriminate himself, he could still invoke his Fifth Amendment right, something that the other guys didn't get in their plea deal. But I know this felt like a massive betrayal to Thug, because, I mean, this is his brother copping the plea, basically saying, yeah, my brother is running a gang and getting out easy while Thug still has to sit on trial. But that's the way it is when things go from the streets to the courtroom. Then you have Martinez Arnold, better known as Lil Duke, Slime Life Shawty, real name Winnie Lee, and Walter Murphy. All took plea deals and pleaded guilty to the crimes they was charged with. And then we got hit with the bombshell plea deal when superstar rapper Gunna decided he was gonna plead guilty too.
And do you acknowledge the following statement? I recognize, accept, and deeply regret that my talent and music indirectly furthered YSL the gang to the detriment of my community. YSL as a gang must end. Is that your statement or acknowledgement?
Yes.
Now, since that happened, a lot of people have been at Gunna's neck online, you know, calling him a rat and all that stuff. But Gunna took a different type of plea than the other guys in this case. He took what's known as an Alford plea, which basically means that he didn't admit guilt, but he admitted that there was enough evidence that a jury might find him guilty if he was to go to trial. Now, regardless of what you heard on the internet about Gunna, in his plea deal, it did say that he retained the right to invoke his Fifth Amendment privilege, meaning that he didn't have to say anything if he got on the stand if he was called as a witness, which means that he probably won't be called as a witness. And up to this point in the trial, he hasn't been called as a witness. But I think that the thing that got a lot of people on his neck was the clip that came out, because the people that were in the courtroom weren't in there with a big camera set up like they normally were. Instead, there was a reporter that was in there that recorded that whole thing we seen on his cell phone. So it's likely that when Gunna was taking his plea, he didn't think it was being recorded. He didn't think nobody was going to hear it. But in fact, there was a reporter in there recording it with his cell phone. So everybody got to see him saying that YSL is indeed a gang and that it needed to be stopped, and that he was sorry that his music helped further the gang indirectly. But not everybody folded out the gate. You had people like Tinquarius Mender, also known as Nard, who rejected the plea deal when it was offered to him.
Ms. Fagan, she's a very fine attorney. Seen her work. But trials, there's one thing about trials, it's uncertainty. You don't know what's going to happen. So you got to beat 4 counts. And if you don't beat them, what will happen is, under this A&C recidivist statute, I have to, under the law, sentence you to the maximum sentence. And then whatever I sentence you to, you serve to the door. That's not anything I have any discretion over. It's not anything because I don't like you or because of what you're being charged with or whatever. Those have nothing to do with anything. That's what the state of Georgia, the legislature has mandated that I sentence you to. So one of the things a plea does is you know what you're getting. It caps your exposure. So, and what the state's telling you today is, if you take the plea today, this is what you're going to get, and this is what I probably sentence you to, and you're done. You got to decide that for yourself. You can't be worried about any of these other folks that are attached to this indictment.
No lie, the judge working for the prosecution trying to talk him into taking that plea deal is nasty business. Although it could have just been pure shock on the judge's behalf, because Nard was facing a maximum of 50 years if he's convicted. And the plea deal that he got was basically a 16-year sentence commuted with 1 year time served, meaning that he basically would get to leave jail that day if he took that plea deal, and he would only have 15 years of probation left to do, which, like I said, I guess could have baffled the judge that he rejected to take that deal, given how extenuating the circumstances are. And eventually he would have his case severed from this YSL case altogether. So that's basically the people that took pleas before the trial even started. But that ain't all the wild stuff that happened before the trial started, because Young Thug's defense attorney was in the middle of giving a statement about some evidence that was being presented, and they're standing at like this podium thing, and there's a monitor on it where like Zoom calls can happen, right? Well, he's in the middle of giving his statement about some of this evidence that may be presented in the trial, and on this monitor, some corn on the cob popped up with a banner on it that said "Free Young Thug." So somebody took over the Zoom call and did this in front of the whole courtroom. And it wouldn't be the only time that the Zoom calls was taken over during this case, but this happened before the trial even started. So it was like an indicator of how this entire thing was gonna go. This thing was a mess from the jump, from everybody from the attorneys to the judge to even the jurors that they were trying to select to do this case. Even some of them ended up getting in trouble. For example, while they were doing jury selection, one of the jurors, or one of the could-be jurors, got in trouble for recording video in the courtroom. And this is something you just don't see a lot in court. Like, you just don't see the jurors get in trouble. But let's check it out.
Good morning, madam.
Good morning.
Madam, just to recap, you were summoned as a juror on the 17th of March of this year to begin the jury selection process. Is that correct?
Yes, sir.
All right. And during that particular process, do you recall, and let me back up just a second, because of conduct that occurred or alleged conduct that occurred on the 17th of March, you were served with an order to show cause. That was filed on the 20th of March of this year to appear on this date, the 3rd of April at 10 o'clock in courtroom 1C. You received a copy of that notice, didn't you?
Yes, sir.
All right. And that notice also gave you sufficient notice that as to why you should not be held in willful contempt for violating the court's admonitions against improper jury behavior, specifically live streaming the jury selection process on Friday, March the 17th of 2023. Do you recall that? I'm going to include that as a copy of the next court exhibit in order. That's your notice that we gave you. So you are at this point in time. Why shouldn't I hold you in willful contempt?
Okay, so I'm going to explain everything that happened that day on the 17th of March.
Okay, but before then, do you recall this court giving you the ad nauseum admonitions about acceptable behavior?
About having phones out?
Yes.
At the moment when we came in,
Didn't I tell you to turn your phone off?
it was, I'm going to be truthfully and very honest. When it was a lot going on, we had just come from different
Answer my
floors.
question first, and then you can explain it. Do you recall us telling you to turn off your cell phones?
Yes, sir.
So basically what happened with that is she claimed that she came into the courtroom. There was a lot of people. She was unfamiliar with the rules. She was, surrounded by all these people. And she said she just kind of took her phone out so she could take a video of herself being there when another juror told her, nah, you ain't allowed to do that. You're not supposed to be recording. So she said she took the phone, put the phone up, deleted the video that she had recorded. And at first they had thought that she live streamed the proceedings, but she told the judge that wasn't the case, that she just took a small video of herself and then deleted it. But needless to say, the judge was not happy that she was in there recording the rest of the potential jurors for this case. But look, fam, that was light work that we just watched. She not the only potential juror that got in trouble. There was another one that also got scolded by the judge. And bro, the punishment that this juror got is, well, let's just say it's a bit unconventional. So when you used to go to school, like middle school, you used to be clowning in class, you get in a little bit of trouble, the teacher come over, the teacher say, you know what, I'm gonna make you write 1,000 sentences to say, I'm not gonna do that again, right? Well, the judge made this juror write a 30-page essay just for the little bit of trouble that they had got in.
When we take this very seriously in order to get a lawful and a fair and a just jury as to both sides. So there are a lot of people that were inconvenienced. I mean, severely inconvenienced. You're not the only person that outlaid money. I examined people yesterday who lost literally hundreds of thousands of dollars trying to be here, and I have to make decisions in regards to that. But I didn't even get a chance to examine you about your circumstance because you went to, you said, okay, I'm going to go and you didn't afford me the opportunity to do that. Now, certainly, I understand you can't be in two places at one time. So, ordinarily, madam, I do find you in contempt, but here's what I'm going to do. Contempt is punishable easily by a fine of $1,000 and or 20 days in jail. I am not going to fine you. I'm going to, well, first, madam, did you attend college?
Yes.
You have a 4-year degree?
Yes, Southern Tech. Yes.
Say again?
Yes.
Okay.
Yes.
All right. What I then want to do is, in order for you to satisfy your contempt, I'm going to commute the 20 days and require you to write a 30-page paper on the importance of jury service. Here's the criteria. You'll have to do APA style. You're going to have to use at least 10 primary sources, 10 secondary sources. You'll talk in a minimum, and I'll write this in the order.
Oh, okay.
You'll have an order. You'll have it before you leave here today. You're gonna write at a minimum, the history of jury service, who could not serve on a jury, because that's very important, because years ago, people that look like us couldn't serve on juries. It was prohibited. I want you to talk about jury service in Georgia and discrimination at a minimum, those 4 things, okay? And you can talk about anything else you want to, in that regard.
Yeah, that's a pretty unusual punishment, getting told to write a 30-page essay. I've seen a lot of punishments handed out in court, but this ain't one of them. But I mean, I do get it. It's not like the judge wants to be out here putting jurors in jail. That would just dissuade people from wanting to do jury duty. So he's trying to give them these quote unquote lenient punishments for the things that they're doing. But it's just something you don't see a lot of in court. Like, yeah, you did this, your punishment is an essay. But apparently the story behind her is she was supposed to be there for jury duty or jury selection. And I guess that she had a trip booked to the Dominican Republic, a trip that she claimed was for work purposes. But I guess she didn't run this by the jury services people or by the judge before she did it. She just up and left and didn't show up the next day. So when she came back, obviously the judge ain't very happy that you just dipped out the country in the middle of this court case without getting any type of approval. So he tells her to write this 30-page essay with 10 sources, and he said he wanted APA style. It's crazy stuff all around. But she wrote the essay, turned it into the judge. He said it was satisfactory, and he dropped this contempt of court charge because that's what he was charging her with. But it wasn't just one juror or two jurors that was getting in trouble, because we seen this problem happening over and over. Case in point is there was another dude who got in trouble who was going to be a member of the jury, a potential juror who was also held in contempt of court. And even though he didn't make the cut as a juror, the judge basically told him he was going to have to do 10 hours of community service where he would talk about the importance of jury duty. And then he would have to, by any means necessary, whether it was taking vacation days or calling in sick to work, he would have to show up for the first 5 days of trial, despite not being picked as a juror.
Contempt is punishable by a fine of $1,000 and 20 days in jail. So why shouldn't I do that?
Well, Your Honor, I was just inquiring about the speed of the speed of the hardships.
But doesn't it go against?
It does, and I take full responsibility.
I mean, the reason that I go through all these admonitions is I told you that we have actually had people do those in other trials, and that affects the fairness, the lawfulness, and the of the trial as to both sides. I mean, that admonition I went through with you all was probably about 10 minutes at least. Yes?
Yes.
So why would you think this would be okay for you to inquire about this?
It was a dumb mistake on my part.
I mean, because that tells me you were listening on the media, which is what I told you not to do as well. Remember?
Yes, Your Honor.
I mean, this is how we have hiccups in trials, and we have to sometimes start over because people don't do what they're supposed to do. So I'm going to find you in willful contempt of my order. I'm going to sentence you to 20 days, but I'm going to suspend those 20 days on the condition of two things. One, you're going to do 10 hours of community service at a school, a synagogue, a church, telling them this is your subject title, Behavior, Choices, Consequences.
Okay.
All right?
Yes.
Then, when we pick a jury in this case, you're going to come for the first 5 days of trial.
Okay.
That will satisfy your contempt. If you don't do the 10 hours and provide me proof, you need to do that within the next 30 days.
Roger that.
Fair enough?
That's very fair, Your Honor.
And it was problems like this that created the circumstances that led to it taking almost a year to find a jury that could be seated for this trial. Crazy stuff. But it wasn't just the jurors getting in trouble, because the defendants in this case, Young Thug and his co-accused, were also getting in trouble. Look, at one point in this trial, like right when it was starting, one of Young Thug's co-defendants, Khalif Adams, was seated in the back of the courtroom and stood up, walked over to Young Thug and handed him something. And you can see the deputies react to it and then walk over to him, and they put him in handcuffs. But what he handed Young Thug was allegedly some pills. Take a look at the footage. right, so you can see him stand up, walk over to Young Thug and hand him something. And why somebody would do this is beyond me. I have literally no idea. But Young Thug and Young Thug's attorney basically said that they don't really know this guy. And the Young Thug didn't know nothing about this dude walking up and handing him this. And then he certainly didn't want to be handed this in open court in front of everybody. But it happened nonetheless, which is just mind-blowing. All right, so moving on. After all of this went down, we finally got into the trial starting, and we all know that that starts with the opening statements from the prosecution and from the defense. Now, there really is no blueprint for how an opening statement should be done. Everybody does it differently. Some people present facts, some people tell stories. It's up to the prosecutor and the defense attorney on how they want to present their opening statements, right? It's kind of like a roadmap of how they're going to lay the case out. They're telling the jury, this is what you can expect to see. This is what we're going to prove during the trial. And at the end, you should find the client guilty. For the defense, this is what they presented. This is why you shouldn't believe it. This is why my client is innocent. Now, for the prosecution, we had the Fulton County Chief Deputy District Attorney, Adrian Love, presenting the opening statement. And she decided that she was going to start her opening statement in a pretty odd way by quoting Rudyard Kipling's intro to the Jungle Book.
Now, this is the law of the jungle, as old and as true as the sky. And the wolf that shall keep it may prosper, but the wolf that shall break it must die. As the creeper that girdles the tree trunk, the law running forward and back. For the strength of the pack is the wolf, and the strength of the wolf is the pack.
Now, I know. Y'all are wondering why in the world would this woman start her opening statement off like that? And it's actually pretty simple. In order for her to prove racketeering in this case, she needs to prove that the co-defendants and defendants in this case performed their illegal actions specifically for the purpose of furthering that criminal organization. She has to prove that they did those acts, not for themselves, but for the gang as a whole. Hence the whole speech about the pack. She's basically saying that Young Thug is the leader of the gang or the leader of the pack. Was there a better way to present this? Yeah, I'm sure that there was, but that's how she chose to do it, with a quote from the Jungle Book. And you know what? That wasn't even the craziest part, because when it got time for the defense to do their opening statement, Brian Still is who gave it, and Brian Still decided that his opening statement should focus on how Young Thug has zero faith in the justice system, basically arguing that he doesn't believe that justice will be done no matter what, which is a really weird way to open to the jury, considering that this whole thing is taking place in the justice system.
In this environment of severe poverty, severe crime, Jeffrey developed two deep, embedded beliefs about our criminal justice system. The first one is that it is not justice. Our criminal justice system was not just, at least for people that he saw. Jeffrey thinks that the entire justice system is corrupt. It should be blown up. And everybody who feeds into that are awful people, stealing lives away from others.
Yeah, pretty powerful words in a sentence, considering again that they're sitting in the court of law. But it really seems like he was just trying to portray the image or get the point across that Young Thug grew up different than most people on the jury, and he kind of tried to portray him as this misunderstood person, being persecuted because of the art that he makes and the help that he offered the people around him. That's kind of the argument that Brian Still is trying to make with that opening statement. And he even went as far as to infamously, I'm sure y'all have probably seen this floating around on the internet, he infamously said that Thug in Young Thug's name stands for truly humble under God, basically saying that it isn't nowhere near as malicious as the prosecution would have the jury believe.
It was his path that he could ever make it as a musical artist and help his family himself and as many others out of this endless cycle of hopelessness, he would be truly humble under God. That's what Thug means.
Not only did he have an explanation for Young Thug's name being truly humble under God, but at the time, Young Thug and Gunna had a song out called Pushin' P, and part of the evidence that the prosecution was using was a picture of Young Thug throwing up what looks to be the blood sign. Well, Brian still says this ain't actually the blood sign. This was to promote their song Pushin' P, which stands for Pushing Peace, and he wasn't throwing up blood, he was throwing up a P for peace.
Prosecution is targeting, that's Jeffrey taking a selfie in the mirror, and he has his hand up, and the indictment that the prosecution had the grand jury return says he's holding up a blood sign, and that furthers this conspiracy. There's nothing wrong with holding up a blood sign, but that's not a blood sign. A blood sign is like this, it looks like a B. That is a P. Jeffrey's fingers are down. And what you'll learn is that Jeffrey just released with Sergio Kitchens, performer known as Gunna, a song that is wildly popular. It's around the globe. It's called Pushing P. And it's positivity. It means any circumstance you're in, if you think positively about something, you can make it through. You're pushing positivity. You're pushing P. Jeffrey is showing the P.
The next thing that we seen was the prosecution pushing to have lyrics from Young Thug songs admitted into evidence by the court. And we seen a bunch of pushback from this in the news. Lots of media outlets covered it. It was a big deal because they were trying to use his lyrics. Now, Brian Steele, the defense attorney, and Young Thug's defense team obviously didn't want them to use lyrics at all because they claim it's all just art. Now, the prosecution said in their opening statement that they didn't chase the lyrics and find the crimes. They found the crimes, and that led them to the lyrics. And Brian Steele's rebuttal to this in the opening statement was kind of funny because his argument was that even if they are talking about stuff that seems violent in their music, they're just studio gangsters.
This is, you will learn, studio gangsters. They're in the studio. They are creating music for us to listen to. If you go to the first one, that's April 20th, 2014. It's a song released on social media, a song called Ooh. Red just like Elmo, but I never effing give go. YFL won't fold, pick his A off a balcony, off in the balcony. There's no evidence anyone got picked off a balcony. YSL, wife at ends, nose, which I showed you. I'm an F for the cash. Then she's getting robbed by Tick. Tick is another name for Trontavious C. He will tell you he had a rough life. He's been in custody. In a Bentley on Wesley, getting trailed by sniper, there'd be no evidence of that. All I ever wanted was the money. Put your hands in the air if you dare. Any MF to step over here, F and N, that's the type of gun. Put him in the wheelchair. These are lyrics that rhyme. Those are taken out of context in that song, but they're lyrics. If we're going to criminalize lyrics, you will learn. We all should watch what we say. It's April 16, 2021. Jeffrey released a song on YouTube, Really Be Slime. The lyrics, my end really, they slime. We committing them crimes. Hop out and shoot. Roll one up for the gang. Want to be a slime? Go catch a body. Me and little bro, we used to steal from the store. We had to stick it and go. That's a confession to an armed robbery. Had to stick them up and go. That's what we're dealing with here. I'm also not telling you that these lyrics are accurate. This is the interpretation of the City of Atlanta Police Department and the District Attorney's Office of Fulton County. You will not hear from the District Attorney's Office. Call one witness who's an expert in lyrics, in rap, in hip hop, in gangster rap, they're not going to do it. They're going to do it through gang experts. Because the gang experts know what they're doing. And they have 5 gang experts. But they really have 1. Because you're not going to get experts from different jurisdictions, from different types of teachings, from different learnings, from different thoughts. Your 5 gang experts in this case from the District Attorney's Office of Fulton County all work together in the City of Atlanta Police Department. Those are your 5 gang experts. They teach each other. They talk to each other. They decide what the rules are.
Now, moving on. Next, we got Angela D. Williams, who is the defense attorney for a co-defendant in this case named Rodalius Ryan. He has been involved in this RICO case and is part of it, but he's actually locked up serving life for another murder charge that he had caught before this. And in Angela's opening statement, she said that the only reason that his case was included in this RICO is because it makes things more complicated and makes the case for Young Thug look worse. She also shifts the blame off of him back on to Young Thug, saying that by targeting her client, they're wasting their energy and effort. They need to focus on the quote unquote wolf of the pack, which would be Young Thug. And she uses, some very colorful vocabulary to get her points across and take some direct shots at the state. She clearly has a bone to pick with the state.
Poor, young, convenient. That's all it takes to become a target of the state. I'm gonna break that down for you. Poor. Rodalius was born on a couch. Let that sink in. He was born on a couch. From day one that he was brought into this world, he has been fighting to survive. The only time the state cares about poor people is when they can exploit them. Rodalius had to do what he's had to do since day one, survive in prison. And if you look at Rodalius, you can see he's maybe 100 pounds soaking wet. So he posts things. He posts things on Instagram. And I wouldn't even call them Instagram posts. I would call it a survival post. He has to boast, he has to be boastful. He has to show people, this is what I have. Because he has to protect himself. It's prison. We're basically distractions. So as a juror, what can you do to tell the state, we're not gonna be distracted. We don't need to listen to filler. You come back at the end of this with a not guilty for Rodalius Ryan. You tell them we do not want to waste our time on fillers. We just want to get to substance. So I guess sit back, enjoy the show, get some popcorn, because this is not justice, this is a circus.
All right, following this, we got into some witnesses getting on the stand, giving testimony, and one of those people was an officer named Officer Monheim. Now, Officer Monheim is a person who pulled over Young Thug at one point in time for an illegal turn at a stoplight, and when he asked for identification, Young Thug didn't have his driver's license on him, so he pulled him out the car and arrested him for not being able to identify himself, and then he searched the vehicle. When he was searching the vehicle, under the passenger seat, he found a weapon that had been reported stolen. And they also found a bag of pills. Now, during cross-examination of this police officer, Brian Steele, who again is the defense attorney for Young Thug, is holding the gun, running a line of questioning on this detective. You can see him kind of like pointing it to the side. The problem is that there's a person sitting right where he's pointing it, leading to the judge getting on his ass.
The 12D, through your work, you find out that this item, from running a computer check, comes up stolen from the serial number. Is that how it works?
Yes.
Okay. And you found the item, though, underneath the passenger seat
Mr.
on the
Steele,
floorboard. Is that right?
I need to teach you about handling weapons. Please point the muzzle always downward, no matter if it's unloaded, okay?
I know it's unloaded, but yes, sir.
You make everybody nervous, okay? To include Mr. Kearns, who you're pointing it at. All right.
I apologize, Mr. Kearns.
So the judge is getting on to him, and he did it pretty fairly, but as time was going on, bro, this judge was slowly losing patience with everybody involved, especially the prosecution, leading to this interaction that we're about to watch involving a list of witnesses. And the prosecution just seems to keep asking the judge the same thing over and over, leading to this right here.
Given that we have witnesses on this list like Detective James Thorpe, who is at the Atlanta Police Department every day, And
You told me that yesterday.
No, no.
And what did I tell you?
Your Honor,
What did I tell you yesterday? I'm not going back through this, Ms. Love.
I'm not asking that the court not require it. I'm asking that the court inquire of counsel whether they have actually made efforts to reach these people. That's all. Because I think it's a little, I'm going to do exactly as the court directed, but Your Honor, I don't think that.
And why are we having the same conversation again, Ms. Love?
Because
this is the third time we've had this conversation. Monday the 4th, we'll look at a hard list for the court's consideration. And is there anything else at this point in time?
Your Honor, did juror number 39?
Would you stay out of my business, Miss Love?
Oh, well.
Stay out of my business.
Judge,
look.
I'm sorry.
I've been doing this a long time. Yes, I have. Yes. And if you really must know, she's going to reschedule her appointment to the week of the King holiday. You happy? No, you're not happy. But anyways, that's the explanation you're going to get. I'm on top of it. Okay.
But that isn't all. During the course of this trial, there were several outbursts and outbreaks in the courtroom that kind of led to chaos ensuing. And one of these incidents happened on January 10th, 2024, after a pretty long day in court when the judge was kind of dismissing everybody to take a break. And there was an interruption over Zoom. Somebody hijacked the link, and this is what happened.
Free fuck, mistrial. Free fuck, mistrial.
Now, at this point, we've seen the judge get mad at the prosecution several times, but it's not like it was only one-sided. He was also getting mad at the defense, too. And one of these occasions happened during the testimony of Trontavious Stevens, or Tick. The prosecution was running their line of questioning, and one of the defense attorneys for another co-defendant decided that he was going to object, and this is how that went.
I think he's finished already. So, were you done with your answer?
It was not a response.
Yeah. All right.
Okay.
So this is yes or no?
Sir, please sit down. Please sit down. Thank you. Just please sit down, okay? I don't need any help from you, okay? All right. And there's no objection on the floor. So, all right?
My objection, Your Honor, to that last series is that the court, I would ask the court to allow the witness.
He's finished the statement. There's nothing else. It's like if he asks to continue his statement, then fine. But sit down and stop interrupting, Mr. Matthews.
And then just a few moments after this, dude goes back to giving his testimony, and the judge gets mad at somebody in the crowd because they're like unwrapping a piece of gum. Y'all check it out.
Excuse me, Miss Love. Madam in the black, get rid of your gum. Remove yourself from my courtroom and get rid of your gum. In the earrings, you. Yes, you. Get rid of your gum. I apologize, Miss Love.
Now, when Tick started giving his testimony, things were going pretty smooth, but he did start dropping a lot of info on the prosecution's lap. For example, when she started asking him about his gang ties.
You were a teenager and a young adult. Did you ever get involved in any gangs?
Yes.
Tell the jury, if you would, the first gang that you got involved with.
First gang that I was involved with was Rock Crew.
Now, would you tell the jury what, and for the court reporter's sake, would you spell rock?
ROC-CREW.
Thank you. And what does rock stand for?
Raised on Cleveland.
Now, were you the only member of Rock Crew, or were there other members of Rock Crew besides yourself?
Yes.
Yes, there were other members.
And just for the record, because I know some of y'all may not know, Tick, Young Thug, a bunch of these other co-defendants, they grew up on Cleveland Avenue in Atlanta. So when they started their first gang, it was called ROC, or Raised on Cleveland. Sometimes, rephrased as Raised on Believeland with a B. But that's what he's talking about. And Cleveland Avenue is known to be like a high crime rate area in Atlanta. And according to Tick, when they started YSL and moved from the Rock Crew to YSL, they were actually actually trying to go in a more positive direction, away from all the negative connotations that the ROC crew had been getting.
We was going through like a phase with the whole Rock Crew gang ordeal. And decided that wasn't the approach we wanted to take anymore. So the Rock Crew gang was known for like committing crimes and like being a gang. We was trying to take a different approach. We had a passion for music. We often listen to music, love music. So we said, hey, we're gonna change the narrative and try to do something positive by create a music organization.
Now, Tick's testimony was some of the most interesting testimony throughout this trial, and it took several twists and turns. Some of them were kind of funny. Like, at one point, the prosecution asked Tick about snitching, what he thought snitching meant and what it was. And bro really sit on the stand acting like he had never heard of the term snitching before. Sitting on the stand snitching and acting like you don't know what snitching is crazy.
Snitching means to you?
It doesn't mean anything to me, but I'm aware of the term that you, yes, I'm aware.
What is the meaning of the term? What's the definition?
It doesn't mean anything to me, but I'm aware of the term.
How are you aware of the term?
I've heard the term.
How do you understand the term to be used?
I'm not aware of the term to be used. Yeah, indicating that a person is a law enforcement or something. Indicating that a person is law enforcement or some nature.
So are you able to use snitching in a sentence?
Yes.
Please use it the way you understand it to be properly used in a sentence.
I heard someone is a snitch.
And please explain how, in that sentence, snitch refers to law enforcement.
I can't.
Why did you use it that way?
I mean, I've seen movies, and that's the direction that the movie was going in. Maybe even used the term. Maybe even got it from like movies. Yeah.
And the way you understand the term, is it a good thing or a bad thing to be known as a snitch?
I really don't fully understand the term.
I don't know, bro. There's something about sitting on the stand snitching and pretending you don't know what it is. It's just kind of funny to me. But anyways, Tick's testimony went on for weeks on end, with a lot of interesting things happening, like I said. And one of those things was when the prosecution asked him to name the members of YSL that were in the courtroom, and he dropped their street names.
Last week, when I asked you whether there were members who were rock crew in this courtroom besides yourself, you said that there were none. Do you remember that?
Yes.
Let me ask you this. Which of these defendants in this courtroom right now are members of YSL Young Slime Life, the gang?
All of them.
And by all of them, would you please call them by name?
Quay, Rod, other Quay, Thug, SB, and yeah.
You said Thug, so you do call Jeffrey Williams Thug?
Yeah.
And Yak, is that Diamante Kendrick?
Yes.
SB, is that Shannon Stillwell?
Yes.
The two Quays, is that Marquavius Huey?
Yes.
And Cromartius Nichols?
Yes.
Lil Rod, is that Rodelius Ryan?
Yes.
Now, does telling on your friends to a jury make you a rat?
I don't know.
You don't know?
No.
Why don't you know?
I don't feel like telling the truth should make you a good or bad person.
Okay, now remember, the prosecution is trying to prove in this case that these gang members took steps in furtherance of the criminal organization. They did overt acts that would further the organization's stance, right? And so while she's got these witnesses on the stand, she's asking them questions about things that they have done to further the gang standing. And it led to one of these infamous moments where Tick told her that he would sell drugs in order to generate money for the gang. And she asked him, she said, "How were you successful at making those sales?" And bruh's response is priceless.
What crimes have you committed to increase the notoriety, street credibility, and reputation of YSL?
So I sold drugs and carried around illegal firearms.
How did those things increase the notoriety, street credibility, and reputation of Young Slime Life?
I don't know if it actually increased, but my approach was to make it known that YSL was selling drugs and willing to protect the selling their drugs with the firearm.
How did YSL protect their territory at 151 Cleveland Avenue?
I never said nothing about protection.
Was the gas station at 151 Cleveland Avenue a location where YSL associates sell drugs?
Yes, that's where I sold my drugs at.
And was 221 Cleveland Avenue a location where Young Slime Life associates sold drugs?
So them two stores, like 5 minutes from each other, I often walk back and forth. Some sales I had down there, some sales I had up the street.
How then were you able to successfully sell drugs?
I never said I was successful.
All right. Moving on. So the next interesting thing that happened in this case is when Brian Steele, Young Thug's attorney, decided that he was going to argue against the idea that Young Thug was a blood, saying that just because he wore the color red and threw up certain gang signs and had a certain lingo doesn't mean he was an actual gang member. And he points to another rapper as an example of saying that this is all just for entertainment purposes. And he points to Lil Wayne, saying that, look, Lil Wayne wears red. Lil Wayne has 5-star tattoos. Just because he has it don't make him a blood, except for the thing is that Lil Wayne has infamously claimed blood for like ever at this point. So it's a terrible example.
On this picture, Mr. Williams, number 31, do you notice any tattooing of the face of Lil Wayne?
Yes.
Okay. And do you have tattoos on your face?
Yes.
And does Mr. Williams or Jeffrey?
Yes.
All right. Now, I'd like to specifically talk, if you don't mind, about the neckline of Lil Wayne. You see it in Mr. Williams number 31. Can you identify or see whether this is correct? Do you see some stars around the neckline?
Yes.
And how many stars do you count?
5.
And how many points are on the stars?
5.
And what color are the stars? And there may be multiple colors. You can name them all if you want. But what's the predominant color, if you think there is one predominant?
Red.
All right. Now, this gentleman is an entertainer. Is that fair to say?
Yes.
And by entertainer, he does movies, right?
Yes.
He does social appearances like you went to go see him at he wasn't performing, but he's just appearing at a club, right?
Yes.
He does clearly music, fair to say?
Yes.
And he's one of the icons of music, is that fair to say?
Yes.
And he's been like that since he's been a child, is that true?
Yes.
And he's still like that today?
Yes.
When he has these stars around his neck, he also sings in some songs about gangs. Is that true?
Yeah, neighborhood and stuff. Yeah.
And that goes to entertainment as well, right?
Yes.
And his videos show things like red hats, 5-point stars. He sings about that. He shows it, right?
Yeah.
It's entertainment, right?
Objection, Your Honor. Speculation.
I sustain the objections.
Is it entertainment to you?
Your Honor, objection, relevance, and speculation as to the meaning or significance or...
I sustain the objection, Mr. Steele.
Do you know whether Lil Wayne has ever won awards for his music and entertainment?
Objection, relevance.
I sustain the objection.
Do you tell the ladies and gentlemen jury if it's part of, in your viewpoint, the American culture, this type of songs about gangs, 5-point stars, etc.?
Objection, relevance, speculation,
It's this.
foundation.
I sustain the objection.
Do you know other artists? And we can say actors and professional sports people who show gang signs. What do you know to be gang signs?
They do movement of their hands,
Yeah. I'm sorry, I cut you off.
yeah.
You said they do movement with their hands, right?
Yeah.
Okay. And have you seen sports figures, professional sports figures? Basketball, football, baseball. Have you seen them go like this with wiping their nose?
Yes.
On national TV?
Yeah.
Have you seen at the Super Bowl performers playing and doing C's for the Crips?
Objection.
I sustain the objection.
Have you seen tennis players? Do you know who Serena Williams is?
Yes.
Have you seen her at Wimbledon doing what's called a crip walk? Do you know what a crip walk is, first of all?
I don't watch tennis.
Okay. Is gang culture promoted via entertainment?
Yes.
You ever hear of the expression a studio gangster?
Yes.
Tell the ladies and gentlemen jury what that means.
Somebody who rapping about, we're in the studio talking about gangster stuff.
And that's for entertainment, right? It's for promotion.
Yeah.
Objection.
Sustain.
Do you know who LeBron James is?
Yes.
Who is, tell the ladies and gentlemen jury who LeBron James is.
NBA player.
Okay. And have you seen him do the wiping of the nose and say slime?
No.
We talked about LeBron James. Have you seen him promote and advertise going around to his teammates and doing the wiping of the nose and saying slime? Have you seen that?
Objection, Your Honor, as to pronoun number 1.
Yeah, I sustain the objection.
Have you seen LeBron James do a video, put out a video, wiping nose, saying slime to his teammates?
I seen LeBron James, he got a different handshake for each player.
Yeah.
Yeah.
So
Describe.
to non-responsive.
Yeah, I sustain the objection.
Describe what you remember seeing LeBron James doing when you say he has a different handshake for each player.
An objection to relevance.
It'll be relevant in a minute. I will tie it up in a moment.
All right, can you answer the question, Mr. Stevens?
Yes.
All right, go ahead.
What do you remember LeBron James doing with each individual teammate that you described? And tell the jury.
He do a lot of stuff.
Did one of them include wiping nose, saying slime? If you remember, if you don't remember, it's okay, Mr. Stevens.
I mean, LeBron may have did it.
God dang, that man is on the stand incriminating Thug, all of Thug's friends, family, the NFL, the NBA. Sheesh. Anyways, that wasn't all that went down because there was more as more witnesses got on the stand. At one point in this trial, we seen the lawyer for Yak Gotti, which is a co-defendant in this, also a rapper, try to file a motion to suppress a video interrogation that had taken place in 2015 where Yak Gotti may have gave the police a little bit more information than he should have. The defense stood up and argued that during that interrogation, Yak had asked for his attorney, and even though he asked for his attorney, the detectives went ahead and continue with the line of questioning. Now, the prosecutors say that the interrogators didn't do nothing wrong. Yak Gotti reinitiated the conversation with them after he had requested his attorney, so they were in agreeing to keep talking to him. However, the judge didn't see it this way, and it kind of made him blow up on the prosecution because they want this to be evidence when clearly Yak Gotti had invoked his right to an attorney and they just ignored it.
During the course of page two, during the course of over 2 hours of the initial interview, defendant did not ask to speak to an attorney. At some point during the interview, Detective Joe Galpin, who was investigating a separate homicide incident, entered the room. Defendant then indicated he wanted to talk with his attorney, and questioning stopped. So Judge Baberman, I can't tell whether or not he took into account what I heard on the video, which was, I need to talk to my lawyer. I don't want to talk no more. That is equivocal to this court, me, Judge Glanville, that he invoked his or withdrew his consent at that point in time and did not wish to speak to law enforcement officers anymore. I understand the state's argument about parsing it out, asking for clarification, but I think that once he's, the appellate, case law that I've looked at, in Paldo and others, he has invoked his right at that point in time, and it's this court's opinion that anything thereafter would be inadmissible.
Your Honor, the court also found that he reinitiated, and that was what.
But that's their issue. That's not my issue.
Your Honor, with respect to the statements that were made after that time, we do have, as I stated, Investigator Thorpe to tell the court on the record, present under oath, that it was not Detective Thorpe, it was the defendant that reinitiated the conversation with Detective Thorpe. Our representations to the court are not evidence, and since the state has the burden of proof.
Okay, but I've seen the video at this point in time.
Video does not encompass when the defendant actually reinitiated contact.
But the problem is, he invokes, and then we don't know what goes on in the 45 minutes, but we come back afterwards, and at that point in time, you don't get to eat your cake, have your cake and eat it too. It's once he invokes, that's it. It's over.
Your Honor,
they should not be bringing him back at that point in time and asking, well, let me just clarify a little bit about whether or not these statements were made to these set of detectives or to Galpin. I think that you all are just annoyed more so that your detective did something that he probably regrets now, and that you all probably would not have told him to do. Don't interrupt this particular investigation or this particular hearing, because what you did is you just now created a wrinkle that now I got to deal with, or whether or not the defendant has invoked his right to counsel. He has. Once you initiate your right, or you revoke your right to be examined and have counsel, and to have counsel present at that point in time, the courts are very, let's just say, cautious about reinitiation at that point in time. And you all presented to me what was the salient point of this particular issue is. So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop. You're not supposed to go out and get cigarettes and do everything else. It's supposed to stop. I mean, that's this court's opinion. So, and that's my rule.
The thing is that, Your Honor, we did not.
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Your Honor.
If you have other evidence independent of this, I'll consider it at the appropriate time.
And we do, and that is what I was asking. So if the court will permit me to actually introduce the evidence that we have, as the court in State versus Paldo 309 Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the State 306 Georgia at 35, Your Honor, Edwards versus Arizona. And, Your Honor, this is a 2020 Georgia Supreme Court case. And
Your Honor, at some point,
Your Honor, I'm sorry, I'm talking, and I don't know why I am being interrupted. I will not stop. I was speaking.
Ms. Love.
I'm sorry, I was speaking.
Both y'all can't talk at the same time.
I know, I was speaking, and I expect you to allow to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
and I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that fact.
Okay, no, you don't. No, you don't.
Your Honor, we have just not been able to present the evidence. That
no, you don't. I get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree, or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
Hey, it really got so heated the bailiff had to get involved. But all jokes aside, I do feel like this was one of the more important parts of the trial because, when the defendant asks for an attorney, man, that's their right as an American citizen to get one right then, not later, not after you do some more questions, but right then. It helps people protect their innocence, right? So I think the judge made the right decision by not letting this come into evidence because, if he let it come into evidence, that would have set a very dangerous standard for the rest of the case. So I think he made the right call on this one. But that wasn't the end because just a few minutes later, the defense attorney representing Yak Gotti actually got to get in there and get him some more words in. And y'all, words he did use.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that opposing counsel can speak. Your rulings at some point have got to be final, Your Honor. Whether you hear from Detective Thorpe or not is irrelevant. He requested his lawyer, he invoked his right to not speak anymore, and I don't care what schmoozing Detective Thorpe did out at the Sally Port, taking my client off camera. I don't know what went on down there. I don't know what self-serving, well, I have some idea. I don't know what self-serving statement Detective Thorpe could possibly give to this court that would cause the court to change their order. This continued going back whenever the state loses in this case has got to stop at some point, Your Honor.
But again, when it comes to this judge, man, he's not just going in on a prosecution. He continuously goes in on the defense too. And at another point in this trial, Brian Steele, which is Young Thug's attorney, gets into it with the judge because the judge basically in front of everybody, the jury included, tells him that he's unprepared, basically calls him lazy. And again, he does this in front of the jury, just belittling him in front of everybody. Now, the audio quality on that clip is actually awful. Like, you guys couldn't even be able to hear it if I played it. So I'm not going to. But Brian still points out that the judge needs to dismiss the jury if he's going to talk to him this way. He shouldn't be doing it in front of the jury. So the judge dismisses the jury, and Brian still approaches the podium so that he can address his problems with the judge one-on-one.
This is the second time that this honorable court in front of the jury has addressed me inappropriately and wrongly. Second time. The first time I gave the state discovery of a song from a Super Bowl weeks before. There was an objection. You assumed that I didn't give it to the state. I didn't want to embarrass the court. So you were yelling at me and saying, do you understand me? Do you understand me? And instead of saying, do you understand that you're wrong? I sat here and I said, yes, Your Honor. That was to protect the integrity of this courtroom and the court. Now you say in front of the jury how unprepared I am. I am not unprepared for anything.
Okay,
I have
Mr.
no.
Steele,
I need to make
Mr.
a
Steele,
record. Your Honor, I
Mr.
need
Steele,
to
wait a
make
second.
this record.
When you keep delaying, okay, and that's what's happening to the court. You keep delaying and elongating and pushing out these particular our ability to present a seamless case in front of the jury. Now, I asked you those two particular questions because if they turned over the audio to you in discovery and you've listened to them already, then you either have an objection or you don't have an objection. And I was trying to solicit from you whether or not we could just go ahead and just hear it. So you can imagine my frustration because all these little delays just elongate out the whole our presentation in front of the jury. That's for your benefit, not for mine, Your Honor. So that's why I've told you all at various times during this particular case. It's not because I want to embarrass you, Mr. Steele. It's just that I'm trying to kind of keep this thing presented in a way that the jury can listen to it.
And the court is wrong. This is the second time. And you know what it does to me? I don't care. I'm hurt because you're a court, but I really don't care. But what does it do to Mr. Williams?
Mr. Steele, I'm not trying to personally insult you or hurt your feelings, okay?
You
are a grown professional advocate. I am a grown professional jurist. And people say things to me that border on the lines of I could take action or not. You have certainly said some of those things to me during the trial of this case. I have let them go. So, sir, that's just the trial. That's just the trial of the case, okay?
No,
but
that man's life is here.
And you know
him?
you're doing a fine job in representing him.
Well,
but you know what? That's just the way we are right now.
I make a motion to ask you to please recuse yourself. I know it has to be in writing within 5 days. If you want me to do that, I'll do it, and that's to go to another judge. But this is what's going on, Your Honor, whether you see it or not. You're yelling at me in front of a jury for nothing, and then you won't apologize. And I did nothing wrong, ever.
No cap, the judge was wrong here. Even if he is extending the time it takes, he's doing it because he's trying to make sure he's got his defense correct. And the judge belittling him in front of the entire jury, it ain't a good look if you're an attorney. That's what you don't want to be happening. But with the judge being, the judge, he went on ahead and denied that motion off rip. He didn't even let it breathe for 10 seconds before he killed it. And that really wasn't the end of this interaction. There was more.
But I'm asking for a mistrial.
Okay, now, Ms. Love.
I don't think it's a fair forum for Mr. Williams. Okay. And I don't want to ask for a mistrial, but I have no choice when the court is saying what it said, and I'm not going to repeat it in front of a jury. That's hurtful. And I'm not saying me. I mean, regardless of what I think of it, it's hurtful to Mr. Williams getting a fair trial.
And this is going to come as a bit of a shocker, but the judge went on ahead and denied the motion for mistrial too. Okay, so moving on. Next up, we got this witness, and we've seen a couple witnesses so far, but we got this next witness named Adrian Bean. Now, the prosecution brought Adrian Bean as a witness to give testimony about a shooting that happened in Atlanta about a decade ago. Now, the prosecution brought him in because they wanted him to say basically the Young Thug was at the scene of a drive-by shooting that had taken place. Now, this drive-by shooting, Adrian Bean was self-admittedly the getaway driver for. Now, after this shooting, this dude crashed the car and a whole bunch of other stuff. And they wanted him to basically confirm these details when he got on the stand. But when he got up there, that's not what happened. He wouldn't admit or verify anything. In fact, his exact testimony was that he was off of so many drugs at the time, he couldn't remember what was happening and don't remember the car crash that happened after it. Now, his testimony lasted technically from the beginning of February to the end of March, so quite a long time, but he was only on the stand for 5 days. During the time that he was the witness that they were going through, though, there was a bunch of tapes and audio, phone calls played, and interrogation recordings played that were recorded after Bean was arrested. And according to Detective David Quinn, this Bean dude was actually like the first person to implicate Young Thug in being at the scene of that shooting.
This sounds like the truth. You're the driver. You really cleared something up for me, the Thug, and I got to go out here and find a picture of this joker because it's important. Because I don't think he should get away with it if he was in the car. You're not making this up. Thug was in the car.
Yeah.
All right. Okay, let me.
Now, I can't testify. I can't do none of that now, you know.
All right, you ain't got to testify. That's on you.
Put me on blast front street.
Well, that's not what I do. What I do is I'm trying to go slow and get all the information I need in relation to you, right? That's all I'm talking about. But the other people involved, I mean, it sounds to me like Thug got you all involved. I mean, I know you're a grown man and everything, but he came down here with an easy way to make money, it sounds like, and it went. Who knew the police were going to be there?
Bro literally said, I'm not going to testify that since you're going to put me on blast. So he clearly told the detective the information that he's reading, but I think he told it to him in like confidence, right? He didn't think nobody else was going to find out. And here this detective is like, I hear you ain't going to testify. I'm going to read what you said anyways. So moving on, the prosecution, which remember, the prosecution is who called this dude up on the stand. The prosecution got the chance to question their witness, and his testimony to them could be pretty much be summed up right here.
My statement is that I don't remember anything from 2013, man.
Now, even though he refused to verify the details or whatever to the prosecution, they got a big W from this because they were able to get all of the audio calls and recorded calls and transcripts basically admitted into evidence, meaning that they could use what he had already said anyways, whether he verified it or not. So it got admitted into evidence, but it's a little more complex than that because Brian Steele, Young Thug's attorney, actually had sit down with this dude and recorded a conversation between them prior to trial. And in that conversation, this dude basically says that Young Thug wasn't in the car and that it was the police who wanted to implicate him in that, like they were trying to put him at the scene.
I am interested in Jeffrey Williams, Young Thug. Was he in, around, a participant, giving direction, anything involved in that event that we're talking about involving Dirty Red in September 11, 2013?
No, sir. Like I explained, when, all that occurred, everything took place, they was, trying to force him in on something that he wasn't even in. Like I said, I'm not going to lie on the brother. You know what I mean? And, he wasn't with us. Young Thug was not in the car with us that day. I don't even know how his name really got mentioned. Maybe it was a lot of hype through the streets. Or, I might have was uncomfortable talking and said his name, but I ain't, implicated him and then saying that he was with us. You know what I'm saying?
And when you say that they wanted him involved in the case or whatever your words were, who is that?
Detectives and other, people that was inquiring. You know what I'm saying? I don't know, discuss the neighborhood or whatever.
The police?
Yeah, police.
The authorities or whatever, the prosecutors, the police?
Yes, sir.
Okay.
So basically, even though the prosecution got his stuff admitted into evidence where he told them that Thug was in the car, there's also now this audio in evidence of him telling somebody else that Thug wasn't in the car and that he was basically forced by authorities to give up Young Thug's name, which pretty much, as far as I'm concerned, causing to question his reliability as a witness, right? The validity of things he may say from here going forward. So then the question becomes, does the prosecution calling this dude on the stand actually help Young Thug's case? And I would say maybe, because we got moments like this right here where he lashed out and basically was like, I don't even know why I'm in court right now.
All this going on right here on this, got me up on this stand, talking about this and that third, all this extra stuff that's going on, Yana. Am I on trial, Yana?
Sir, you just have to answer the questions, unfortunately, at this point in time, okay? That's all I can tell you.
Am I on trial?
No, sir, you are not on trial. But you have been properly summoned here as a witness, and you're subject to examination until I release you.
I never consent to do none of this, sir. I ain't signed nothing. My name ain't on nothing. They come give me, y'all don't threaten to lock me up. Hey, I got a family too.
Look, and when I say bro was fed up with this, like bro was really fed up. Y'all gotta hear what he said right in the middle of being questioned.
You just heard that you explained that you qualified it as the detectives and police. And I asked you the authorities, the police, the prosecutors, I just made it broad, that they forced Jeffrey Williams into it. Did you hear you say that?
Man, can I get a water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
Bro is tweaking. That's crazy. Anyway, so moving on from that. The next thing that happens is we get this witness who was apparently the victim of an armed robbery that took place that Young Thug was supposedly a part of. An armed robbery, by the way, that wasn't included in the indictment against Young Thug. But we get this witness who doesn't want to be identified. She only goes by AB. And apparently she skipped out on coming to court. Now, the prosecution said that they sent her a subpoena and she ignored it, but she says that she just never received it. However, the police went to the address that she had on file and they found her there. They arrested her on a material witness warrant and forced her to give testimony in court. Now, there's a conversation to be had about whether forced testimony is helpful or unhelpful, but in this case, if the prosecution thought that she was going to give them anything of value, they were wrong, because this is basically how that went.
Learned after asking that it was a friend of your child's father, known to you as Thug, who was at the door.
No.
Do you recall telling the police that you opened the door and let Thug inside your home?
No.
Did you ever say to the police that Thug's brother was also with him?
No.
And do you recall telling the police that you turned your back on Thug's brother, and a person you called DK after letting them in your home?
No.
Do you recall telling the police that you turned your back on them to walk into the kitchen to make your baby a bottle?
No.
Do you recall telling the police that when you went to the kitchen, Thug's brother put a silver 9mm to the back of your head?
No. And my baby didn't even drink bottles. My baby was breastfed. So no.
Did you tell the police that the two suspects, that Thug, his brother, and DK demanded money from you and your gun?
No.
Yeah. So that happened when the prosecution tried to question her. And the very next day, AD got cross-examined by Keith Adams, which is another member of Young Thug's legal team, because he got a whole legal team working for him. And I'm not even going to speak about it. Y'all just listen to what was said.
You were asked some questions by the Assistant District Attorney, Ms. Love. Is that right?
Yes.
You remember her asking you at one point, are you afraid of Jeffrey Williams? You remember that question?
Yes.
And she may not have said Jeffrey Williams. She may have said, are you afraid of Thug? You remember that?
Yes.
Okay. And your answer was no. Is that right?
Yes.
You have no reason and had no reason to be afraid of Jeffrey Williams. Is that right?
No, I don't.
Okay. In fact, when you testified yesterday, you were on edge. Is that fair to say?
Yes.
You didn't want to be here.
Yes.
And part of it is because of the interactions, and your reaction yesterday was based on the interactions you had, not with Mr. Williams or anyone over here, but with the district attorney's office. Isn't that true?
Yes.
You told us when you were back there that they had been, quote, harassing you for a number of months. Is that true?
Yes.
And in fact, you said that prior to coming out and testifying, that the only person you were afraid of, you didn't want to be around, was Investigator Hamilton from the District Attorney's Office. Is that true?
Yes.
Mr. Hamilton had contacted you prior to yesterday. Is that right?
Yes.
Mr. Hamilton had harassed you. Is that correct?
Yes.
In fact, you told us when you were back there that you didn't want to come out and see him because he had sexually harassed you. True?
Yes.
You felt like, and you told us, that you were really concerned about coming out here.
I'm going to object as to relevance.
I'm going to overrule the objection.
You told us that the times when he would contact you, it seemed like he was trying to date you.
Yes.
He wanted to meet you, supposedly to talk about the case.
Yes.
But you didn't feel comfortable going to meet him by yourself.
Nope.
Because you didn't feel comfortable going to meet him by yourself, you brought your 20-year-old son with you.
Yes.
Was that before or after you met with Mr. Hamilton and he told you, don't talk to nobody else?
That was after. He told me before that. I came in, I seen Miss Love, and that's when I told y'all yesterday that me and Miss Love, we only discussed for a brief because they was like trying to tip me.
Family, y'all gotta remember, these last two witnesses was called by the prosecution. And you know what? We heard something similar to this in the YNW Melly trial too, where they had a witness on the stand who said she wasn't scared of Melly, she was scared of the prosecutor. And we're seeing the same thing happen here in this Young Thug trial. Just a coincidence that I found curious. But that's not it for AD, because she was back on the stand a few days after this to verify everything that she was saying about this investigator. And they did that by throwing text messages up on a big screen and reading it in front of the whole court.
Now, how about the next one? That same night, Wednesday, February 7th, 6:45 p.m., where he says, hit me up if you're bored later. We're not going to talk shop. Remember that text message?
Yes.
Did you talk to him later on?
Yes.
Did y'all talk shop?
Yes.
What do you want to talk about?
Going out.
Going out? Going out as in walking out the door or going out on a date?
A date.
And this is February 7th of 2024, this year, when the investigator for the DA's office is supposed to be talking to you about a case, but in fact is calling you, talking to you about going out on a date. Is that true?
Yes.
Did the fact that this employee of the district attorney's office was trying to date you come into your mind as you're thinking about whether you have to come in here and testify or not?
Yes.
Yeah, that is not looking good for the prosecutors or the district attorney's office in this case. That is a really bad look. But it really doesn't end there. It just continues to go on. This is actually the case that never ends, because we got another state witness. This time it was a dude named DK, a member of YSL, who actually copped a plea earlier in this case and pled guilty to conspiracy. You know, somebody that you think would be a big witness for the prosecution since they're calling him to the stand, actually got up there and said that he went to prison at one point in his life, and while he was childhood friends with Thug, after he went to prison, he never reconnected with him and said, I don't have no relationship with Thug.
What is your current relationship with Mr. Williams?
I don't have a relationship with him.
When did that relationship cease?
It never ceased. It just, I went to prison.
And while you were in prison, you did not maintain your relationship or friendship?
When you in prison, you don't retain no relationship. All that in.
And since you got out of prison, did you not rekindle your friendship when you got out of prison?
I had more important relationships to worry about than friends. Like my kids.
The prosecution then went on to ask this dude about a bunch of tweets he sent out around 2013, 2012, where he would use gang lingo. He would change the C in words to B, you know, signify his allegiance to the Bloods or whatever. And he basically just said, look, I used to do a bunch of that stuff when I was young. I was dumb and young, and that's what we was doing.
And I want to go down to August 25th, 2012. Can you read that tweet on August 25th, 2012?
That's the song.
Okay, what does it say?
It's been a long time coming, baby. I just called to see how you been doing lately.
Now, you just said it's been a long time coming. Is there a B or a C there for coming?
To be.
Okay. Why would you tweet it as a B?
It's just what I was doing back then. I did a lot of stuff without meaning or purpose. I was childish, young, dumb.
So yeah, another state witness that's not really being super cooperative with him. So what does the state do in like retaliation of this? Well, they basically read out the details of his plea agreement for the whole court.
Did you ever create a group called YSL?
A group, yeah.
Okay. Was it something else besides a group?
Not to my means of knowledge.
And what does number 1 say?
YSL, otherwise known as Young Slime Life, began as a neighborhood group but evolved into a gang.
Okay. And did you initial number 1?
Yeah.
Those are your initials, right?
Yeah.
Okay. So when I just asked you, was YSL a gang? Why did you tell me you don't know? Did you not acknowledge that in this document?
Yeah, but it say evolve. I don't know when it evolved into a gang. I know when we made it, it was a neighborhood group. It was a group of guys from the neighborhood. I made it a music group.
And in this acknowledgement that you initialed, you said it evolved into a gang. That's what you initialed.
Yeah.
Okay. So why?
I don't know when it evolved into a gang, though.
I didn't ask you when. I just asked you, did YSL become a gang?
Yeah.
All right.
And basically that happens over and over and over again in this dude's testimony when he's confronted with things that he had said to law enforcement or information he gave them in regards to his plea deal. But overall, not very helpful for the prosecution at all. Now, keep in mind, I've been showing you guys the highlights from this trial. We kind of running through the highlights and why this thing is really a disaster. But a lot of people have started to question at this point, because it's been like 2 years, is this trial ever going to end? And you know what? That's something that even the attorneys are starting to question.
We are losing our jurors. We are losing our jurors. I look over there at them and they are trying their best. They are trying their hardest. Often they are taking notes, but other times they have just tuned out.
I have spoken with our sheriff, and consistent with court, if necessary need be, we'll start having court on Saturday and Sunday. Yeah, well, that's my call. So if you don't want your Saturday and Sunday sucked up, I think we need to work a little harder in terms of being able to streamline, and that goes to both sides. And look, I don't want to work that way too, because it's me and my staff and my team and the sheriff and his team and everything else. But we will do it, because we're going to have to recap some days. I don't want to be in 2027 trying this case. Or as Mr. Steele said, I want to be here next Super Bowl trying this case. I have power of contempt. I don't want to use that. I don't. But it's come down. We've been in trial a long time. I think I've been very clear with everybody about my expectations, which
serve you all and your ability as advocates in this case to try the best case you have.
Yeah, everybody involved is pretty much tired of being involved with this trial, from the lawyers to the defendants to the judge to the jury, who, by the way, only make $25 a day to be there. So a lot of them have lost their income over the last 6-7 months because of this, because they're only making $25 a day. But the main reason for this is because when this whole thing started, the prosecution had a list of about 700 witnesses. At this point in the trial that we're at right now, they had already done about 40 of them, and they had about 150 left to go because the list had been shortened from 700, to around 200. But clearly everybody's becoming restless and tired of it because of the sheer number of witnesses that are left. Based on how long it took them to get through the 40 that they went through, how long is it going to take them to get through the next 150?
I do have some concerns about 120 days of trial time. That's going to take almost 4 months. And, I'll remind the state, you told me, or Ms. Hilton told me, it's going to take about 6 months. At this rate, it's going to be 12 months, and that doesn't include anything that the defense may choose to. I'm concerned about your case, Chief, at this point in time. The defense will present whatever they wish to do with, and I'll deal with it. We'll deal with it accordingly. But
we were trying to be finished by June, frankly, as I told the court earlier.
Yes.
We can't control cross-examination, and that has extended our estimation of the time that we set.
Well, like I said, if you disclose things, if you don't disclose everything, and we don't disclose things timely, then what I'm doing is I'm taking up more time. What I want to do is I don't want us to take up 2-3 hours. I can't do that anymore. So I'm telling you, you need to make very sure that you've disclosed the evidence and you'll be able to tell me what day you did, because if you can't, I'm gonna exclude it. That's my remedy at this point in time.
Now that brings us pretty much up into present day if you're watching this video when I put it out. And it's still pretty explosive in the courtroom. For example, just last week, we had the prosecutor trying to introduce some new evidence, and the judge basically getting mad and blowing up because of the timing of the introduction of this evidence.
I'm not going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
talk to them. We have said we don't agree.
Then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that.
The information they are seeking.
Oh, it's going to be inadmissible right now.
I'm saying, Judge, that you said to file a motion. There's nothing.
I'm not going to have any more discussion about this, madam. I'm not.
Talk to them this morning about that.
Well, you know what?
And I attempted to try to talk to them earlier this week.
Well, then that's why we have to.
The court punishes the state because the defense.
I'm not punishing anybody, but but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them what I sent them last week. A whole week and a half ago, 2 weeks, Your Honor. And I have said I would like to discuss.
Our jury's coming in, madam. Our jury's coming in. Have a seat.
Yeah, you could tell tension is running high, and it's mostly because of how long this entire thing is taking. This started in January 2023, so it took a year to get the jury seated, and then we're in the 5th month since opening statements took place. And at the rate that it's going, it's like super likely that we're going to be watching this trial all the way in 2025, which is absolutely crazy. But we're going to move on because the next thing we seen in this was a argument that happened between, again, the judge and this time Brian Steele, Young Thug's attorney. And the argument was over whether a witness that is testifying can also be an expert witness. So basically, there's an investigator in this case who's going to be a witness, and Brian Steele has a problem with the way that he was certified as an expert witness. Apparently, it was done in front of the jury, his certification.
So my point is, there was absolute candor always with the court. I did take it as a fait accompli because I don't know why.
No, but that's not true, sir. And that's a misstatement and a mischaracterization. You're telling me that I've already made up my mind at that point in time. It was all but a certain conclusion. It was not, sir. That's not the way that this court looks at its role as the gatekeeper and its role as a referee.
Well, I understand that you're offended.
I am offended because it's not true in terms of what you were given.
Well, I'm going to tell you I'm offended because no other time in this trial have you given a instruction to the jury before you found somebody expert to say this person's going to give expert and lay testimony? So as a listener, it was already a fait accompli because you already instructed the jury that that witness was going to provide expert and lay testimony.
Did you object at that point in time?
Your Honor, I believe.
Did you object at that point in time?
I believe you already.
Did you object at that point in time, sir? I'm asking you a question. Did you object to at that point in time saying, Judge, she hasn't been qualified as an expert as of yet? I don't think you should read that instruction as of yet.
It would have been frivolous to say.
But you didn't object, though, did you?
Listen, I'm not playing.
I know I'm not. I'm asking you. Look,
I'm just saying. To me, there's nothing but candor in my motion, always with the court. I love this court. I'm not attacking you. I'm telling you how it appeared to a reasonable person.
So Brian still is upset that the judge called this investigator lady a gang expert in front of the jury with, no official certification or whatever. But the judge, like we've seen multiple times so far, was basically like, I ain't hearing none of that. It is what it is. Let the jury come in. We're going to let this woman testify. And so that's what it was. Now, the next thing that we seen in this was basically like hours and hours and hours of the attorneys going to sidebar with the judge. And one moment that came out of this was over one of these sidebars where they were discussing a video that had been posted to social media allegedly in 2015 of Young Thug saying that if you snitch, you was gonna die.
So a lot of they mama, a lot of they kids, a lot of they brothers and sisters then get ready in the courtroom and tell the God honest truth. Don't get it. Y'all need to get killed, bro. You snitching from me and YSL.
And basically the prosecution wanted to put this in evidence, but the defense was saying, nah, because there's no way to really prove when it was recorded. You could just prove when it was posted, but there's no proof of when it was recorded or what it was in reference to. It's just an out of place and out of context piece of media.
Sergeant Gaither, I'm going to ask you a few more questions about State's Exhibit 112, Bravo, Bravo. Did you recognize the person who was depicted in the video visually?
Yes.
All right. And did you recognize the voice of the person depicted in the video?
Yes.
Was the video obtained from a public social media site that was accessible to anyone who is looking at that site?
Yes.
Okay. We will come back to that.
Basis, sir.
Matters not the charge.
I'm gonna overrule the objection.
You may answer.
YSL.
Thank you. And Your Honor, with the exception of the video that we are redacting with the court's ruling, I don't have any further questions at this time. With the court's permission to play that video after it's properly redacted and defense has had an opportunity to look at it.
Counsel, can I see you for a second, please? Just.
He is putting forth himself as a figurehead. He's saying that's for me and my gang, me and YSL. Y'all need to be killed. Those words are wholly inconsistent with this notion that we just produce rap music for the good of everybody. And so, Judge, given that the speaker of the snitching comment is doing nothing but co-signing the main message that Mr. Williams is speaking, the first contention that identification of all speakers is necessary before tapes are admitted refers to one of 7 requirements often enunciated by courts for the admission of tape recordings. But the primary aim of these requirements is to give the assurance that the tapes are accurate. The goal of accuracy is sufficiently satisfied even when all the speakers are not identified, as long as relevant speakers are. In the challenge recordings in Bagley, the court found that the more relevant party was the caller, who in each case was an identified member of the conspiracy. And insofar as the conversations may be deciphered to involve the heroin scheme, the names of the recipients of the calls were not critical to the tape's accuracy or their relevance. Therefore, the trial court properly admitted them despite the failure to identify every party. So for our purposes, as we've alleged and stated from the beginning, the person that we identified in the overt act listed in the indictment was Mr. Williams. His words were the overt act that we alleged in the indictment in Act 26. Mr. Williams is the relevant speaker. His words are the relevant words, and the persons who are behind him talking are simply co-signers.
Okay, you said that twice now. Okay, at least
I won't say it once.
all right, so let me hear from your colleagues across the table.
It's a repost. What you're being shown is a repost. Are they the same statements? People change things all the time. Like the state was going to redact here. In the background, we started out with the state saying you only hear yeah by other identified persons. You clearly hear the person saying, I'm going to lie on God. Snitching, I'm not going to say it, but B-I-T blank H-E-S. F, and then the N blank G-G-A. That's as far as I can blank you. So help you God. It's 17 seconds, and there are multiple speakers. It's not just two speakers, it's multiple speakers that right now the state may be able to get it in. It's just like you told me. I'm not saying this may not be evidence that's important to the case. What I'm saying is there has to be the same foundation that the state lays, that you're making me lay, and that's what the case law supports. Now, if you let it in, an appellate court, they may say it was error, harmless error, it wasn't an abuse of discretion, it wasn't abuse of discretion. We understand that, but we're here now. The state cannot lay the foundation. They need a different witness.
Okay, the court's had an opportunity to kind of consider the issue presented to it as to the exhibit. That being states 112 Bravo Bravo, the digital media of the incident involving the posting of January 26th of 2015. I'm going to sustain the objection as to foundation at this time. However, much like many of the rulings I've made, they're subject to reconsideration. In this particular circumstance, I believe that it is the opinion of the court that the original video as presented would at least the source would have to be at least identified for the purposes to make sure that there were no alterations of that particular video. I don't know whether or not they are, but I think that'd be part of the foundation in this case. So, for example, when we haven't had testimony of this quite yet, if it can be shown that this particular video came from Mr. Williams' Instagram page or some other social media site, and it's public and posted, and then it was re-grabbed and reposted, then that would finish the foundation in the court's opinion. And the other issues that the court would take up at that point in time as to what it would play and for what purpose.
And then after that little argument and all of that, we had one of the defense attorneys for Young Thug actually taking the podium saying that he had something on his mind. He needed to get it off his chest and proceeded to call out one of the prosecutors, saying that the prosecutor was lying to the judge's face.
I've got to say this because I've been sitting there after our conversations. Let me just preface it by saying, in any of our objections, whatever, you make a ruling, sometimes we win, sometimes we lose, we move on. That's fine. If after your ruling, I've got a case that I want to bring to your attention, I say, Judge, reconsider your ruling based on this case, and you consider it, that's fine. If you don't want to consider it, that's fine too. But what I found objectionable, and I want the court to address with the state, is what happened at the bench earlier. There was an objection to the video. You made a ruling. We moved on. The state came back up and made representations to you. And they weren't representations based upon some new case law that they had found. There were representations, misrepresentations that were made directly to you, all of us standing there right there at the bench. She said something very, very fact specific in an attempt to get you to readdress the issue again. Madam Prosecutor said, I want you to listen to the 17-second video, because what you had based your ruling on was that the parties in the background couldn't be identified, all right? And Madam Prosecutor said to you, and was not accurate, and I'm going to be charitable and say that she was disingenuous. What she said was, these people in the background, the only thing that you hear are people saying, yeah, yeah. That's it. When Mr. Steele corrected her and said that's not true, she said, Mrs. Steele is not accurate. What Mrs. Steele just told you is not true. The only thing you can hear in the background is yeah, yeah. And actually, when she stepped up there, it was in an attempt to act as though she didn't know what your ruling previously was, because their attempt was to go ahead and play the video at that time, despite your previous ruling. My point is this. After you decided to reconsider, you wanted to hear the video yourself, you had a chance to hear it. You had a chance to hear what we had already heard, what we knew it said, what they knew it said. And there are at least 5 or 6 different things on that video audio that were in contradiction of what Madam Prosecutor said. On God, snitching, I'ma tell a lie on God. That's what I'm talking about. No back and forth with you, bro. I'm not just saying that for emphasis. I'm saying that because what she said to you was inaccurate. At some point, Your Honor, I'm asking you we've had this conversation about candor with the court over the course of the past number of weeks.
3.3.
Yeah, we've had that conversation about it. And when we step up to you and we make a representation, it ought to be candid and it ought to be truthful. And what she said, and look, if she wins the motion, ultimately she wins. But you don't do it by standing there 3 feet from you in your face and lying to the court. And that's what she did. And she knew what she was doing, and it's not right.
I would not have asked the court to listen to the 17-second video.
But what you did tell me, Ms. Love, wasn't the entirety of what was purportedly on States 112 Bravo. It did have other statements on it. It's different if you'd have told me, Judge, there are statements on there. Probably need to listen to them for yourself. Not just yeah.
Your Honor, my recollection, and I'm going to speak candidly because it's been
I would hope there'd be nothing less than candor.
And Your Honor, that's what I've been pushing for all along. There have been times, as the court is aware, that we have been at the bench and misrepresentations, bald misrepresentations have been made, and the court has seen my reaction to them. I am the one that's constantly saying I have a duty of candor to the court.
All of you do.
We do. And when Mr. Adams just read those series of things that he read, those half of what he said, I didn't catch. The part that I did catch and remember is the part I kept repeating just now, snitching. And I didn't even recall that part was there.
Zealous advocacy is one thing, but it should never be confused for misstatements or for anything else that's not less than candid to the court. I think both sides, you all are fighting very diligently and valiantly about your prospective sides. And as I said a couple of days ago, what the public sees is, there's friction between the state, the defense, and the court. That is natural, and it is good for the system because it shows that we are not in collusion with one another. Justice is what it will be, and whatever this jury will decide. But what I am going to just advise everyone to kind of relook is what you tell each other, what you tell me, because there have been times where I have not received, I would consider what
what is accurate information. Let me just put it that way.
And that is basically where we're at with this Young Thug trial. They've paused it. Things are supposed to resume next week. And so far it's been an explosive trial. I would even venture to say it's been a disastrous trial, but it's probably going to go into 2025. So I figured I would make this video for anybody that ain't been keeping up. This is like that one hitter quitter. You can watch this, you know, everything you need to know about what's happening in the trial so far. As things progress, I may cover it as it happens now that I'm all caught up, or I may just double back and make like a part 2 of this video in the future. Y'all let me know which one y'all think I should do in the comments below. But basically that's it for the video, guys. If you enjoyed the content, be sure to hit the like button, subscribe, tap the notification bell so you get notified every time I upload a video. As always, it's been fun rocking with y'all, man. I'm out.